Hello everyone, I am Danish Ajaz Sundro and this is my student ID card and my student ID number is 24112183. I will advise Harim, a jewelry reseller, on her right and remedy under the Sale of Good Act 1979 regarding issue with goods received by Rivaj UK, analyzing three areas with reference to case law and statutory provision. Legal framework. Sale of Good Act 1979, Section 13 Sale by Description, Section 14.2 Statutory Quality, Section 14.3 Fitness for Purpose, Section 14.2C Exception for the seller added key implied, and Section 15 Sale by Sample, Unfair Contract Act 1977. This transaction between Rivaj UK and Harim Jeweler is a business-to-business sales governed by Sales of Good Act 1979. We will examine potential breach of statutory terms, focusing on statutory quality and fitness for purpose. The first issue involves a custom-made necklace and earring. Harim specified the need for hypoallergenic titanium-made jewelry relying on Rivaj UK's expertise. Since the jewelry caused an allergic reaction, it is clear it wasn't made of titanium, breaching Section 14.3 of Sales of Good Act 1979, which require goods fit for purpose, specified purpose. In the case of Baldry versus Marshall 1925, the buyer requires a car for torture, but the seller provided a Bugatti that wasn't suitable. The court ruled this was a breach of the implied condition for the fitness for purpose under Section 1979 Sales of Good Act. Remedies for hypoallergenic breach. Given the breach of fitness for purpose constitutes a breach of condition under the Sale of Good Act 1979, especially under Section 14.3, Harim has the right to reject the goods and a full refund. Additionally, she may pursue damages for any loss or harm resulting from the breach includes potential impact on the fashion show. Note that in reference to Section 15B seems inaccurate in this context. Section 14.2 and Section 14.3 are more relevant to fitness for purpose and statutory quality. Issue number 2. Discounted rings with missing gems. Harim was informed that discounted rings were reduced due to missing gems, which was accepted. However, upon inspection, 2 out of 5 rings were found to be in good condition, and this dispensary raised concerns about whether the purpose accurately matched their description, potentially constituting a breach under the Sale of Good Act 1979. In the case of Belly versus Taylor 1967, a car was advertised as a 1961 model, but was actually a combination of 2 different models. The court held that the car did not correspond with the description, constituting a breach. Remedy for defective rings. Given Harim was aware of the defectives, rejecting the goods under the Sale of Good Act might be challenging. Refund for the challenging. However, she could pursue a partial refund for the rings that were wore condition that described potentially claiming a price adjustment for the discrepancy. Issue number 3. Choker sets wrong color and quantity. Harim ordered 10 blue and 10 maroon chokers, but the delivery was not only short of quantity ordered but also includes green choker, a color not agreed upon. This constitutes a clear breach of Section 13 of the Sales of Goods Act 1979 as the goods do not match their description. In the case of Remore and Co. versus Langner and Co. 1921, goods were delivered in incorrect packaging. Despite the correct quantity, the court held that the buyer was entitled to reject goods as they did not match description. Remedies for wrong chokers: breach of condition, right to reject. Given the breach of description, which is a breach of condition under Section 13, Harim can reject the entire delivery of the choker set. Alternatively, she may choose to reject only the non-conforming portion. The green chokers and claim a refund for those items, not the Section 15B typically pertains by the sample, whereas Section 13 governs good matching their description. No refund policy. Rivaj Juke's sales store policy of no refund exchange cannot supersede statutory right under the Sale of Goods Act. The Unfair Contract of 1977 requires any exclusion of liability for a breach of condition to be reasonable, meaning the store policy may not be reasonable if deemed unreasonable. Conclusion: necklace and earring, breach of Section 14(3), right to reject. Harim has solid ground to reject. The jewelry due to breach of the Sale of Goods Act 1979, the necklace and earring for the failing to meet fitness for purpose Section 14(3), and the choker set for matching their description Section 13. She may be entitled to refund potential damage. Rivaj Juke, refusal to refund cannot be override statutory rights. And bibliography and references. Thank you so much.